Good afternoon. My name is William Baloy, and welcome to this government press briefing. Our apologies that we're supposed to start at 4, but due to unforeseen circumstances, we have to start 15 minutes later. But thank you very much. There's been in the public space the whole issue of the government's response to the Marikana issues. And today, government is going to provide update on Marikana reparations. The update is going to be given by the Solicitor General, Fezisani Pandelani. I think they can call you Robert. The Solicitor General, Fezisani Pandelani, from the Department of Justice and Constitutional Development, will be giving us the government's update on the Marikana reparations. Solicitor General, you can come to give us the update. Kati.
Afternoon. Thank you very much, Mr. Baloy. My name is Fezisani Pandelani. I'm from the Office of the Solicitor General. I'm the incumbent Solicitor General. We've been requested to, in fact, talk about the status in the coordination and management of matters relating to the Marikana litigation. Call it reparation, if you may. And we thought perhaps it is very important to give a narrative from where we stand. There have been quite a number of matters relating to the unfortunate incident that has been triggered by the Marikana violence. Immediately after the Commission of Inquiry was constituted, a number of matters were in fact preferred as claims against the state. From where I sit, I think it could have better been handled much better in terms of other alternative dispute mechanisms. But for the purposes of this meeting, I just need to indicate that there have been 5 firms or legal representatives for groupings of claimants in these matters. We have, in fact, centralized all the matters relating to the Marikana incident to the Office of State Attorney in Pretoria, so that there could be proper management and coordination in the manner with which we deal with these matters. In relation to the classes of claimants, there have been claims that have been lodged by the Vets Law Clinic. That was one claim that has actually long been settled. We have, in fact, we don't have any outstanding matter with the Vets Law Clinic in relation to those matters. And there are matters that have, in fact, been commenced by SERI. Mr. Choe, SERI is... Yes, the Socio-Economic Right Institute of South Africa has, in fact, preferred quite a number of dependence claims. Those would be claims for those that have, unfortunately, passed on as a result of the Marikana incident. There were about 56, if I'm not mistaken, matters that have been instituted via the SSERI. 55 of those matters have been finalized. And payment has been effected to the claimants via the Socio-Economic Rights Institute. And if you were to, in fact, look for the figures, the matter that we settled with vets to start with was 3,995,121. And as I've already indicated, we don't have any outstanding matters that are being handled by the Vets Law Clinic. In relation to matters that SERI dealt with, Socio-Economic Rights Institute, I can report, as I've already indicated, that in fact I made a mistake. It's 36 matters that were in fact preferred against the state, 35 of which have settled. and the quantum of the amount that has been paid to date is 69,083,005. So that is 69,083,000 rands. And that amount has been paid. It is confirmed as having been paid. I will come back to the claims by the Socio-Economic Rights Institute of South Africa, because there is something that in fact is another leg of what they believe should be compensated for. So if you were to invoke the once and for all rule, you would actually accept that having paid this the just under 70 million rand on behalf of the 35 families, the matter would have been resolved. But not so, because the Socio-Economic Rights Institute came back to us and said it needed what it calls general and constitutional damages for and on behalf of all the 36 claimants. Now, general and constitutional damages is not something that is easy to quantify. It's very difficult to quantify, but we needed to be reasonable under the circumstances. And to the extent necessary, we believe that we, as the state, we needed to approach this matter with some degree of humanity. And without prejudice, we then said we are prepared as government, as the state, to pay to all the claimants that were represented by the Socio-Economic Rights Institute an additional 500,000 rand without prejudice, of course. That claim for the general and constitutional damages is still in court, but we needed to offer 500,000 rand pay family. And that offer has been rejected. I think it must be placed on record that that offer has been rejected. In fact, a counter offer was that they needed 1.5 million per each of the claimants that they were representing. And that is where the stalemate is. And also accept the fact that the offer by the state of the additional 500,000 rand comes against the backdrop that we've already paid under 70 million rand. And if you invoke the once and for all rule, you would not actually look back. But we are saying we are dealing with human beings here, and these are matters of importance. And the 500,000 rand that we are offering has been solely in the spirit of good faith to those that in fact might have lost their loved ones. That matter is not resolved, as I've already indicated. The Socio-Economic Rights Institute is sitting at 1.5 million rand pay claimant. We're sitting at 500. And as matters stand now, the only way in which we can resolve this issue will be to refer back the matter to court, perhaps if it is not resolved. But it is our fervent desire that perhaps they could have been able to reach us to some degree to say, look, I mean, 500,000 rand is over and above what we have already, in fact, settled in relation to the quantum that has been preferred. And so the other category of claimants is represented by colleagues Maluleke Msimang attorneys. And these are not related to those that have passed on. The majority of these matters are for those that suffered injuries. And to the extent necessary, we are in fact negotiating with the colleagues, because we believe that if we're to wait for the outcome of court processes, that might be another lengthy period. So we are invoking a combination of both, alternative dispute resolution, so that we can bring these matters to settle as soon as possible. As I speak right now, I think the colleagues representing those claimants that have been injured have, from Maluleke Msimang, have submitted substantively almost all the documents that are required to quantify the damages for the injured personnel. And what remains is for them to now consider our offer as the state, and we have actually made that offer. And once the offer is accepted, then we will be able to remit the necessary payment to the attorneys representing those that were injured. The other firm of attorneys that is representing those that were in fact injured or alternatively assaulted is Tata attorneys. Tata attorneys have in fact submitted quite a number of claims on behalf of the injured personnel, almost 27 individuals. we are in the process of negotiating with them for a possible settlement. So we are also dealing with those matters. It's on course. They've given us 80%, if my memory serves me well, of the documents that are required in order to substantiate and quantify a claim for personal injury. And to the extent necessary, we are dealing with those that, in fact, are complete for the purposes of settlement, and will deal with the balance of the matters as and when other reports have been finished to us. The other firm of attorneys that have preferred matters against us was Nkome Attorneys. Nkome Attorneys, in fact, represent almost 275 claimants. Now, we have to this date, in fact, paid Nkome Attorneys just under 100 million rand, but to be exact, it is 97,685,000 rand that has been paid on behalf of the claimants that are represented by Nkome Attorneys. It is not the entire list of the 275. We settled on this 97,685,000 on behalf of 253 claimants. Meaning, if you look from the 275 individuals that they've been representing, there would be about 22 that remain. Now, we are, in fact, in negotiations in relation to the 11 claimants that remain to constitute the number 275. And in relation to the other 11, there are other outstanding issues that, in fact, have not been resolved as between us, but we are willing to engage with them. And the outstanding issues that might not have been resolved between us might be attributable to a number of instances. It could be that they cannot locate their clients, could be that they are unable to send their own clients for examination by the state, because as you would know, in matters of this nature, we also need a right to go and examine those claimants. There could be other reasons as well, but we wait ready to engage all the representatives of the claimants that have lodged claims against us. Fundamentally, those that passed away, all of them, we have in fact settled those matters. Those that are still alive, we are in fact requesting that we need to be ramping up issues of settlement. But as it were, we are actually in the receiving end from a litigation point of view, not because we are not a caring state. We are a caring state. We are in fact engaging with all the attorneys that are representing the claimants in this matter, and we are desirous that these matters cannot be with us forever. And for that reason, the Office of State Attorney in Pretoria has centralized all matters so that we don't actually have to have many offices dealing with these matters. All these matters are centralized in one office. A directive has been issued to the head of Office of State Attorney in Pretoria to make sure that these matters are finalized as soon as possible. The gentleman that is sitting next to me, Mr. Chowe, has been in fact assigned to be the person that coordinates with all the legal representatives of all those claimants whose matters are still remaining. Now, there could be other attributes that could be there that we might need to talk to. We don't have a direct relationship with the claimants. I've been talking about a category of legal representatives for and on behalf of those claimants. And to the extent necessary, if any claimant that has lodged a lawful claim against us arising from this incident wishes to verify the facts, they are free to we are government. We cannot actually operate strictly on a client attorney confidentiality, because records that are available with government should be shared with those that have got a vested interest in those matters. And to the extent that any of the claimants, even those that we might have paid, is now alluding to the fact that they are not being taken care of, or alternatively, that they've not received anything, it might actually be proper for them to approach the Office of the State Attorney in Pretoria to verify the facts, because we are not in fact dealing with them directly. We are dealing with them on the basis that they are principals and they've appointed attorneys, and we do not want to be involved in the relationship between attorney and client to the extent where perhaps we could ask, has this particular client been paid or not? But if it is that any of the people that in fact mandated any of the legal representatives to deal with these matters still feels aggrieved and doesn't have direct answers by those that in fact were representing them. And that is not to detract anything from the professionalism of the attorneys that are dealing with these matters. They are free to approach the Office of State Attorney to make a determination of the status of any of those matters. We are willing to deal and finalize these matters. Unfortunately, once you choose to be legally represented, we are precluded from actually approaching that particular client to say, can we sit down to settle this matter? We need to go via the acceptable prescripts and speak to the attorneys. Even though you could be my neighbor, and you have lodged a claim arising from the Marikana incident, and you have in fact preferred that claim via a lawyer somewhere else, I am, in terms of the applicable prescripts, precluded from even approaching you to ascertain whether you have been paid or not paid. It's unethical on my part to do that. But we are saying, to the extent that there is quite a number of other niggling issues relating to these matters, those that are impacted are free to approach the Office of State Attorney in Pretoria to check the records for verification, so that we can actually deal with those matters that remain unsettled. But as I've already indicated, perhaps the first thing to do will be to ascertain with those that have been representing the individuals that have lodged the various claims. From the category of matters that in fact we have been dealing with, we've had matters relating to loss of support, past hospital and medical expenses, future medical expenses and hospitalization, emotional shock and psychiatric injury, grief and emotional suffering, loss of family and or parental support, and general damages. We recognize, and those are recognizable heads of damages in terms of our common law, and we don't have a problem with those. But there is yet another category amongst the matters that we might not be settling as at the moment, of those that were injured and hospitalized. And whilst they were lying in that hospital bed, they probably would have been police within the ward. So whilst we are prepared to pay for their injuries, such as has been sustained from the incident, there are those that in fact have lodged other claims to say, as they lay there in that hospital bed, they want to sue under another head of damages, which is arrest and detention. Now, there is no agreement as to whether any one of the injured persons that might have been hospitalized could ordinarily, in terms of our applicable prescripts, be deemed to have been under arrest when they were in fact lying in those hospital beds. So that is another category of matters. However, we also need to be alive to the fact that we have not been strict with issues such as prescription in the strict sense of the word, or how service has been affected, because ours has been that we need to look at these matters. We are actually, as government or as the state, liable to compensate all of the claimants to the extent that those claims could be validated. Thank you very much, Mr. Padoi.
Thank you very much, Mr. Pandelani, for that information. It's quite important for us as a nation to know that as part of the healing process of what happened in Marikana, there have been this process of making sure that a continuous engagement with the legal advisors continues, and for the people to be compensated. And thank you very much for also mentioning that the state has compensated, but is an ongoing process because you are busy engaging with the lawyers. On those basis, let me invite questions from our media so that you will be able to assist with some of the answers. I'm going to request Ishmael to take us through the questions, but before Ishmael can give us the online questions, let me check inside the press room if there are members of the media who want to ask questions. I'll check by a way of hands if they are here. And then if they are not yet ready with the questions, let us then take the online questions. That is Slimal.
Thank you, Chairperson. We have three questions. Our first question is from Gavin Whittles from ENCA. Siri has revealed that the 69 million rands paid to the families of the deceased is for loss of support from those that died. Is it correct that no compensation for damages to the families, which include hospitalization and trauma sustained post-massacre, has been paid? Is it correct that none of the mine workers who were injured and therefore unable to work have received compensation, and how much is the government offering injured mine workers in compensation? Our next question, Chair, is from Haupalelwe Palaitzile from Jacaranda FM News. The government is talking about claims to 36 families. We know that there are actually 44. What about the rest of the families? Sibanye has confirmed it will be helping the rest of these families with litigation in that regard. Our last question, Chair, is from Teto Matlakwane from Eyewitness News. How many years after the massacre did the government begin paying the concluded claims? That's all for now, Chair. Thank you.
Thank you very much, Ishmael Selimal, for the questions. I think that will be the first round of questions. And given that there are a lot of figures that are quoted, but also other legal steps and processes that have to be followed, would make sure that we get the statement and we post it, we send it to all the journalists who are in the platform so that they can further interrogate and it can guide them. Tate Pandelani, I think we can give a try to some of the questions that have been asked. Khadi?
I will attempt to answer the questions as I recall them, but where I'm not actually giving an answer, I will ask Mr. Chowe to assist. I think in relation to when did we start effecting payment for the claimants after the processes have been concluded, it goes back to the 15th of August 2018. That's when we were in fact supplied with all relevant documentation in relation to the various claims that might have been lodged. In relation to the question that there are about 44 families that might have lost their loved ones, I must actually indicate that we have actually identified that one or two of the other firm of attorneys, the 5 firms of attorneys, take into account the fact that the Vets Law Clinic as well dealt with a dependency claim, which is a loss of support. And if you add it to the 36 and also look at perhaps the other attorneys, some of them have taken 1 or 2 of the matters, and you will probably find that the number comes to 44, if we're not mistaken. So to the extent necessary, also, we as the state can only deal with those matters that have been lodged with us. We can only respond to claims that in fact have been preferred and they came to us via normal processes. And we might not be able to know of all the other families that probably might have been impacted, but we have done a thorough investigation in relation to the claimants, be it in respect of personal injuries, be it in respect of loss of support, and we are desirous that all of those should be settled. If and in the event that there is anyone from those families that in fact feels that justice has not been done, I've already indicated that this is an ongoing process, and they are free to approach the Office of State Attorney in Pretoria to check the records, to check the lodgement of the claims, and to the extent necessary, we will in fact sit down with empathy and deal with that claim and also explain to those families. Let me go back to the issue of whether there is the amount of 69,000 from Mr. Whittles is adequate to compensate the families. I've already indicated it depends how you phrase your claim, and we could assist to the extent that is necessary, because some of the other aspects might in fact be answered by the letter that Siri wrote to the president, which is suggesting that there should be some form of a relief fund, which should be going on for some time, that will in fact pay the families 12,500 rand per month. For a certain period. I've not actually sought to deal with those, but it is there. We have actually tabulated it, because that proposal has been made last year. But as we sit right now, we ask them to outline the parameters under which that scheme of arrangement for payment of 12,500 per month to the families for a defined period, what it is predicated upon. And as at this day, from October, was it August last year? Either August, when that letter has been written and we went back, we have not actually been given the parameters under which that should happen. That should also be seen against the background that we have actually made that offer of 500,000 rand over and above the 69 million rand that we have paid. If you were to quantify 500,000 rand and multiply it by the number of families, which is 36 in total, you will then realize that that is an additional 18 million rand. And to the extent that they are wanting 3 times that amount, and we cannot reach each other, it remains now, insofar as that head of damage is concerned, it remains for an independent arbitrator to, in fact, make a determination on the reasonableness or otherwise of that amount. But we have reached out to say, look, to the extent perhaps that the quantum might not be sufficient to assist, we are willing to go this far. But we don't have a bottomless budget, as it were, and any amount that the state pays must in fact be fair, just, and reasonable under the circumstances. I think, Mr. Chowe, you will take the last question. There was a last question, unless if you remind me what it was. Ishmael?
The last question is from Teto Matlakwana from Eyewitness News. How many years after the massacre did the government begin paying the concluded claims?
So it would seem that I've answered that by indicating that that was way back in 2018, which is almost 3 years back, 4 years, if you may. So that is the period when we started paying out the claimants. I don't know if there is any residual question that I might have actually left out.
No, you covered everything. We have 2 more questions, Chair. I don't know if...
Yeah. All right, I'll allow Mr. Chowe to actually deal with the other issues.
Thank you again for the clarity that you have provided. I've been informed that some of the issues that you wanted that the Chowe to address, you have covered them. So allow us then to invite another round of questions. This time we'll also take our online questions. Date Ishmael Suleiman.
Thank you, Chair. We have 2 more questions. The first one is from Atandi Wesaba from the Mail and Guardian. When the state says they have settled with all those who passed away, and then the state says that they are still in court regarding damages, which one is it? Have claims been settled or not? And then the last question, Chair, also from Mail and Guardian by Niren Tolsi. The 69 million rands for the families was for loss of support, amongst others. The Live ECD main inquiry awarded constitutional damages which the state paid. Why the intransigence regarding constitutional damages regarding Marikana? Why is the government heckling over the settlement of Mr. Mpumza? He did not have children, but he supported several extended family members, as so many South Africans do. That's all for now, Chair.
Thank you very much. May we take also the questions that have been asked, and from there on I think we'll go for the very last round of questions before we release you. Thank you.
Thank you so much. the Solicitor General, Mr. Pandelani, has actually given a proper clarification of these matters. In as far as the question as to whether if the 69 million rand doesn't represent all the claims, why then are there still issues with the other claims which are remaining? We need to be reminded that the state is approaching this matter as amicable as it can. And on that basis, what the state says is that in as far as the constitutional damages are concerned, these are matters which, one way or another, they may actually cross over to the damages which are already been paid for. So if one were to go to the constitutional damages, one will have to make sure that there is no duplication of claims. And the state doesn't necessarily say we are not going to pay, but I will suggest that what the state says is that we need to look at what the damages are. If there are damages which are already paid, which are fair and equitable, one will have to approach the constitutional damages with a lot of caution and to avoid the possibility of duplication of claims and payments. And as the Solicitor General have said, Mr. Pandelani, is that we need to be really careful when one were to spend whatever amount of money which the government has in its coffers, especially taking into account that these are public funds, and we really are intending to make sure that there is a just and equitable payment to all the families. So I would suggest that, yes, I would agree that the ECD many matter, there are constitutional damages made, but one has to make sure that in this case, there are certain damages we are paid, and we need to be careful not to duplicate what has already been paid. That will be the answer which I can provide.
Thank you very much, Ntate Isaac Chowe. I will then request you that we take the very last round of questions, and then you will be able to then round up. Tate Slemal.
Thank you, Chairperson. We have two last questions. The first one is Zolo Timasango from Ikwekwezi FM, Current Affairs. Will government subject these entities to audit by the Office of the Auditor General? The last one, which also is from Million Guardian, we understand that the claim against the President and Lon Min was tied to the claim against the government. How far is this matter? That's all, Chair.
Thank you very much. And that brings us to the end of the round of questions. So we'll then ask the team to respond and then also to round up. Thank you very much.
Thank you very much. I think there is a question as to whether entities will be subjected to audit. I'm not so certain whether it relates to entities representing claimants or not, but there is no intention whatsoever for us to be subjecting legal representatives to audit. And we don't believe that, in fact, they've done anything untowards to the claimants that they're representing. I think all of them would be bound by the oath of office, which requires that they need, in fact, to act in the best interest of their claimants. So there is no way that we could, in fact, subject those that are assisting the claimants to claim from us to audit. And that is just on that particular aspect. There is a question that, in fact, came through. The second question...
from Mail Guardian.
Yes.
We understand that the claim against President Ramaphosa and Lon Min was tied to the claim against the government. Yes. How far is this matter?
Right. All the claims in the main, there were quite a number of respondents in relation to these matters. Lon Min was one, The state is in fact represented by the president in all instances. But under these circumstances, what we have seen in the citation is that the South African Police Services has been cited in some of the matters. The National Prosecuting Authority has been cited in some of these matters. And to the extent necessary, the state attorney is able to deal with those matters based on the quantum that is being claimed. Because if you are suing one arm of the state, whatever money that is paid from that arm of the state can in fact be aggregated, and we can know how much it is that one is claiming in total. So I think that answer would in fact could be gleaned from the court documents, but also the Office of the State Attorney will be able to provide answers insofar as those aspects are concerned. But generally there was another question that in fact sought to establish, that's the online question, the types of claims that have been lodged with us. In the broad category of matters, as I've already indicated, loss of support is loss of support by those that were in fact dependent on the deceased as at the time that he died. There are quite a number of other issues that are looked at, but that is one category of matters that we are dealing with. The other category of matters that we have, broad category, is the unlawful arrest and detention. That is another head of damage or claim that in fact has been preferred. There are also claims that fall under the category personal injuries. There are those that in fact had gunshot wounds, and others have in fact alleged that they've been assaulted grievously so, and therefore they needed to be compensated. Those will be the broad areas. And in relation to claimants, we have received claimants from a range of categories. We've received claims from spouses. We have received claims from parents. We have received claims from grandparents. We have received claims from siblings of the deceased. We have received claims from children and stepchildren of the deceased. We have also received claims from nephews and nieces of the deceased. We have also received claims of cousins and uncles and aunts in the whole conspectus of matters that in fact have been preferred against the state. And those are the broad claimants, category of claimants that are there. I'm not actually here to talk about the legal principles, but these are the matters that we are in fact interrogating as at the moment, if not already settled. But as I've already indicated, we are willing. In fact, Mr. Cho, who just spoke now, is in fact tasked with having to take this process forward and ramp up attendances relating to these issues. With your permission, Mr. Baloyi, let me take the other questions that in fact are here, so that we can do justice to the questions that those that are not in the room have asked of us whilst we can. I think the first question in relation to the to the question that came from Govan Whittles, we have actually dealt with to the best of our ability in relation to the number of those that might have claimed under loss of support in relation to a family member that might have died, as to whether are they in total 44 or whether they are in total 36. I've already indicated that all the other claimants have had a claim or two in relation to loss of support. There was a question from Jacaranda FM, and that also hinted on the number of claimants. I think whether is it 44 or is it 36, and if that is so, what are we doing with the rest? But our answer is we're able to trace all the families in relation to those that might have passed, and any of the five main representatives could be representing any of those 44 members. The biggest number was by Siri, which represented 36 in total. Of the 36 from Siri, we have not been able to settle the one matter, and that could be attributable to quite a number of things, either inability to trace relatives or any other claimants, but those facts can always be gotten from the office. I think there is a group of 270. Can you break out the nature of the claims? I've already outlined the three broad categories under which the claims have been lodged. It's either on account of the death of the deceased, or alternatively personal injury to self, or loss of support to injuries that might have been sustained. There was another question from Niran Tulsi from the Mail and Guardian. I think that question actually says it goes back to the life acid demeni issue. It requires of us to interrogate the issue of constitutional damages. And I think perhaps there could be a platform where we could deal with that, because we have not really excluded that aspect at all and said it's non-competent or incompetent. We are still looking at these matters that have not been settled. There was another question, perhaps from the Mail and Guardian, which I have in fact dealt with, because it sought to deal with those that were defendants in the matters, and I've said we are in fact dealing with those matters holistically as matters where claims are being preferred against the state. The last question, in fact, I think might be unfair on me to in fact talk about litigation relating to General Pierre. I would not be able to talk to that issue. I don't think it actually formed part of the specs of what we needed to be dealing with. She could be answerable to that question. She's still alive. We wanted to deal with real life issues and actually interrogate those issues, but to the extent necessary. The second part of that question that comes from Niran Tulsi says some families have as many as 18 dependents, which means R500,000 does not stretch so far. How has the state factored this into its quantum? Who has authorized the state payment for Pierre's litigation? And for the same reasons, I might not be able to talk to the latter part, but perhaps without actually appearing to be non-responsive. The theory of settlement is something that is well established in our law, and those legal representatives that are representing these claimants will know much better on what heads of damages to claim. But when you come to settlement, and it should be accepted that we are not in fact fighting on the merits of the matter. Merits have long been established, and once you accept that you have accepted merits, the only thing that remains is to now deal with the quantum. The quantum is the determination of the fairness or unfairness of an amount that should be paid to a claimant. Now, it's not a thumb suck exercise that you need to go through. There are quite a number of metrics that you could invoke. Of course, you could in fact sit down and say, you know what, just for the sake of us making these matters go away, we can actually pay you so much. So it's give and take. Or you could actually do as Syria's proposed, if you may. But we cannot litigate, we cannot defend these matters and also determine the process that those that are claiming against us should follow, except where we were to go through alternative dispute resolution, which is always available, because alternative dispute resolution is available even when a matter is sitting in court. Hence, you see that the category of matters that are there, we are in fact making offers of settlement, notwithstanding the fact that there's a parallel process that is happening in court, because you cannot in fact perpetuate these matters and deal with them by way of a court process, because you don't have control over the court process. But you can sit down around a table and make a determination, and how you make that determination takes a number of factors into account. There should be quantification. There are actuarial calculations that needs to be factored in. So if perhaps you earn 20,000 rand and your neighbor earns 1,000 rand, unfortunately, the quantum that is going to be paid might not necessarily be the same. It can't be the same, because dependency is based on a number of permutations that will have to be put in place. But I believe that those that are representing claimants have, in fact, under trying circumstances, done their best. There is no way that we can actually sit here, pontificate or demonize them on the way that they dealt with those matters. Equally, we are a caring state, and in terms of the provisions of the Constitution, we need to be responsive to these claims. And of course, when one stands here, you stand here and where that gap that says we might have probably not gotten things right, but it is not for lack of trying. And we are here, in fact, to demystify the narrative that the government is not carrying. We are, in fact, coming up with these figures, not so much to demonstrate that we've paid some money, but also to demonstrate that we have actually been responsive from the first time that we were seized with these matters, and we continue to be responsive to an extent where it is now us, in certain instances, that are following up with those that are claiming against us to say, how far are we? And the person that makes an offer under these circumstances still is the state. Now, if we make an offer and have to follow up with you having made that offer without there being any response, there is a problem insofar as that aspect is concerned. But we are happy that we have dealt with our counterparts with a measure of professionalism. There are, however, niggling issues relating to those claimants that cannot be traced. I think there might be 11 from the total number. Those claimants that might have died and perhaps from injuries, where we need to be notified that the claim now is no longer for personal injuries, but is for the death of that person. But that death ought to be connected. There needs to be a connection between the death and the injuries that have been sustained. But of course, if we are approached as a caring government, we can look at the circumstances and see whether within permissible limits we are able to deal with all those matters. Thank you very much.
Thank you very much, SG, and for the comprehensive explanation of the processes. However, SG, there is one issue that I think you need to rectify, and that is the issue of the date of when did government started to pay for the dates. Maybe if we can allow you to come and just put the correct date here. Thank you.
Thank you very much, Mr. Baloy. I think there are quite a number of facts. We're dealing with quite a number of information and data. But just for the record, and in relation to the question that has been asked as to when was the first payment ever made by the state, it would have been the 30th of June 2017 and not 2018. 2018 was the second batch of claims that we in fact started dealing with. 30th of June 2017, I think that's when we paid the 3.9 million rand through the University of the Witwatersrand Vets Law Clinic, which represented one of the families of those that were claiming for loss of support. Thank you very much.
Thank you very much from the Government of South Africa, GCIS. We thank you very much for the information provided, and this brings us to the end of the press briefing. Thank you very much.